I like to first of all, I appreciate a lot Tilman, Douglas, we call them Till and Doug, for joining us in this webinar. We have been discussing this topic with them a lot. It's a new topic for us in Brazil, not that new for them in the US and EC, but they will provide us, share with us their views and explain to us where the authorities in the US and Europe are in relation to this topic. Just to give you some context, we are having this discussion together with the committees of competition and compliance and investigation of IBRAC. In the compliance investigation committee, we are discussing all the aspects of internal investigations. We have just had a very interesting, successful series of webinars about internal investigations, how to negotiate deals, leniency agreements with the authorities in Brazil, not only the competition agents, but other agencies in the country. And we have detected that this topic of investigations in merger cases are rare in Brazil, very rare in Brazil. But we want to anticipate trends and want to hear more from you what's happening abroad. So the challenge of this panel is to show how incentives can change during internal investigation, what can happen in this kind of reviews when you are dealing with authorities in a completely different context from what we are discussing here in investigations or in cartel cases. So it would be great to hear from you. I'd like to introduce Milena Mundim from the competition committee. She is one of the members of the merger unit, the merger working group of IBRAC, and she is a partner at the Marest. And she kindly accepted our invitation to co-moderate this panel. And Milena will introduce our distinguished panelists here. But first of all, Lauro, if you can say some opening words, please.
Yes, sure. Thank you, Ribas. It's a pleasure. It's a pleasure to have you here, both Tin and Doug. As Ribas mentioned, it is a quite new, let's say, discussions we are having here. So it is very interesting for us, for those who has already participated in this kind of murder investigations before, not here in Brazil, but due to international transactions, we have participated in some of them during the last years. It was really, like, say, let's say, for us in Brazil, it was very strange, actually. The 3 times I have to participate in one of these, it drives me crazy. It's like we are doing like some document review for cartel cases. It was like we have the technical assistant looking for documents. We had to work on depositions. We have to look for specific documents requested by the authorities. So it took us a long time, really, to prepare all the documents. Not to forget that some of them we have to translate to English because they are in Portuguese. So we have to translate to English. So it was really, really complicated. And I remember well that we have to put together a 10-people team to make the document review and to work on their position. So it was really complicated for us. We were actually, now we are prepared to do that, but for the first time it was really a mess to us, and we are not used to do this kind of work in mergers investigations. But anyway, it will be great to hear from you what your experience is and what kind of, let's say, advice you can give us, you can give to the Brazilian firms to be prepared to this kind of investigation. Thank you again very much, and I pass the floor to Milena. Please, Milena, go ahead.
Thank you, Lauro. Thank you, Ribas. And first of all, I have to say that I'm really happy to be here, to have the opportunity to discuss a topic that is very interesting to me, which has to do with trends in merger investigations. And so I think that first of all, I'm going to explain very, very briefly how it works in Brazil. And then I think you have already explained why this is a relevant topic to us at the moment. And then finally, I'm going to introduce our speakers and of course, let them speak. So how exactly does it work in Brazil right now, like information gathering, and what type of documents the CADE, the Competition Authority, asks to see? As you all know, we have the fast track and the non-fast track procedure, right? What we call the regular procedure. So in the fast track, we basically need to submit the transaction documents, annual reports, financial statements, and sometimes like any third party report to indicate where market shares came from, but that's it. That's very simple. In the ordinary procedure, we have a different sections because we have a long form where we need to submit like market studies and especially presentations made to the board and anything that shows like business plans, strategic decisions, things like that. But it's not massive. The authority is usually satisfied with like the presentations to the board, which shows the rationale behind the deal, the notification. So, but we understand that's it, like from the Brazilian side, that's what we see. And we understand that there has been a recent shift in other jurisdictions like the EC and in the US. They are requiring like a massive amount of documents to look into those transactions, especially the big mergers. So what we want to see now is what they look at, what are they asking for, and what has motivated this shift, like in those jurisdictions. So we have here today Tilman Kuhn, Dr. Tilman Kuhn. He has a doctorate degree from the University of Cologne in Germany and an LLM from the University of Amsterdam. He's a partner at White & Case, based both in Düsseldorf and Brussels. And Till has extensive experience with both the Bundeskartellamt in Germany and with European Commission, and he will kindly share it with us today. We also have Douglas Jasinski. He has both a bachelor and a doctorate degree from the Catholic University of America. He is a counsel at White & Case in Washington, D.C. He also has a lot of experience in the US. He has written a number of articles and speeches covering several issues involving competition law, and he will brief us today on his recent experience with both the FTC and the DOJ. So, Till and Doug, thank you so much for being here with us today, and the floor is yours.
Thank you very much, and let me kick it off by thanking you again for having us. Always a pleasure to be with such a distinguished crowd of Brazilian practitioners and many friends. So great to see you at least virtually, hopefully soon in person again. Also special thanks to Doug for joining me here. Doug is actually on vacation, but I've told him so much about this crowd that he said he can't miss the opportunity to get up early on vacation and join me here. So thanks, Doug. And I'll kick the ball over to you when I've rattled through my stuff here. It's indeed a topic that's very dear to my heart because while at first may sound a bit procedural and dry, it does have a very significant impact on the ability to do deals, on the deal timing, and ultimately, and that's kind of the tricky part, that's a lot of judgment involved there and a lot of personal and subjective views, but I do think it does have an impact on the substance and the outcomes of cases. Maybe to start with the European Commission. The EU system is procedurally relatively similar to the Brazilian system and different to the US system. It's a front-loaded system in which you have an explanatory, descriptive notification that formally starts the process. And even in simplified cases, even in fast-track cases, but of course, especially in cases that raise some substantive issues, you do have a pre-notification phase in which you submit a draft to the European Commission. They give you questions back. You submit a revised draft with the answers, and this can take quite a long time. In difficult cases, this can easily be 3 months, 6 months, sometimes 8 months. There's also a strategic question of whether you really want to avoid a phase 2 in-depth investigation and hence prefer to spend a little more time in pre-notification, in which you can actually even already agree on remedies to try to get a phase 1 clearance with remedies. Or whether you want to push forward because you think it's a phase 2 anyway, and let's not waste more time in pre-notification. There's some strategic calls to be made there, but you always have this pre-notification phase. And this is the first phase where the EC may ask for documents. And then you have phase 1, phase 2, and I'll go through that, where there may be additional document requests. Traditionally, the EU system is not very document focused. It's really focused on the notification in which you explain market definition, market shares, competitive dynamics, and then the traditional market test, right? The agency questions customers, competitors, maybe suppliers, and then on that basis, they will reach their view. You may have some market reports as well, but that was the way it used to be done. And then maybe 5 years, for some cases 10 years ago, the EC started doing something that was really the core of the US system, as Doug will explain, for any in-depth investigation, namely also focus massively on these internal documents to get a unfiltered and unsanitized view of how the parties really view market definition, competitive dynamics, closeness of competition between the parties, innovation, all of these things. And just to give you a couple of numbers, the telecoms cases, there's been a lot of mergers in the mobile telecom space in a number of countries. They are typically very document heavy. It's really just one relevant market, but it's still like a 700-page decision typically at the end of phase 2. And these prominently feature a lot of internal documents. I personally was involved in Dow DuPont, one of the 3 big agricultural mergers, in which we had to submit more than 400,000 internal documents. And then in Bayer Monsanto, allegedly, it was almost 3 million internal documents that have been submitted. And now I'll talk about that a little bit in more detail. Procedurally, it's very different how these documents are requested, how much time you have to produce them, to review them, both for privilege and for substance. But it's not only that they collect these documents, it's really these documents have become a key additional source of evidence. It doesn't replace the market test or anything else, but it's additional evidence. And one of the reasons may be that in the early 2000s, the European Commission got really beaten up badly in court. They lost 3 merger prohibitions that they've issued. All of them got annulled. And the EC was criticized heavily by the courts for relying on not enough evidence. So overall, the investigation has become more comprehensive. Additional sources of evidence have come into play. More economic resources have been added. So more economics work is being done. And I think the other aspect was really learning from the US, where this has been going on for decades, this document focus. The one difference is, contrary to the US, we do not have depositions. We do not have formal witness testimony by the authors or recipients of these documents, or generally decision makers in the companies, which I think is a huge disadvantage because all documents need to be put into context. They may not reflect a company leadership endorsed view. It may not be a reflected view. It may be some low-level employee who's speculating about something, and there's no clear hierarchy of the evidence or how these documents compare to the market test, or a single document versus the 400,000 other documents that you found. What does it mean? Is it representative? These things are very much unclear. But still, they've become a key source of evidence, and the Commission relies heavily on them. Let me just see if I can click this forward. Okay. If you want to understand a little bit on I flipped one too fast. I said it has an impact both on the substance and on the timing, and this is just a set of statistics that are updated in 2017, and I haven't updated them again for today, but the trend is the same. You can basically see easily that this focus on internal documents has led to a real extension of the actual review timetable, right? The timetable in the statutes is still the same, right? Pre-notification has no deadline. Phase 1 is 25 working days, so 5 weeks. If you offer remedies, it's another 2 weeks. And then phase 2 is supposed to be 90 working days with certain extensions that you can agree or that apply automatically if you offer remedies. But this focus on internal documents has led to longer pre-notification and especially a longer phase 2, because very often you get this document request. You have to produce literally hundreds of thousands of documents in response to a single RFI, and you have 1 week for that. So even collecting them, loading them up into a review system, deduplicating them, and takes about a week. And then you have to review them for privilege, because you have to produce them in a specific way, and I'll show you an example. But you will hold back privileged documents, but you don't have time to look through 100,000 documents manually to check whether they have privileged information. So all you can do is type in certain search terms that seem to suggest privilege, or names of the external lawyers or something like that, and then hold them back. And then the Commission will say, well, but not all of them will be fully privileged. So you are not complete with your document production until they're convinced that everything you've held back for privilege is actually privileged. And they may really go through it with you one by one. They may want personal confirmations, stand there with your good name and say, I've reviewed this, this is fully privileged. And then they may trust you on that one, but they will press you hard. So it's really become the norm that in phase 2, you will have the clock stop because you cannot produce these documents within the given time frame. And in Dow DuPont, we lost about a month and a half in total. So if you just compare the review timetable with the United States, the Bayer Monsanto case, it took longer from the first contact with the Commission until the final decision by the European Commission, so by the competition authority, than it took an AT&T Time Warner to reach a first instance court judgment. So it's really very difficult, as you all know, to hold these deals together for such a long time, to deal with all of this uncertainty. There may be an impact on the stock price and what have you, but that's really been a very visible impact of this focus on internal documents. This, of course, leads to very questionable practices on legal privilege. It leads to also an information overload on behalf of the Commission. All they can do is really to look for smoking guns with search terms. I don't think that they can really reach a balanced conclusion of what the full body of evidence tells you. Is this selective document that they found, is it representative or is it an outlier? It's really impossible to do this in the time frame that the European merger regulation allows you. And it does lead to a bit of a prosecutorial bias, a confirmation bias. You know, they have a theory of harm in mind. They look for something that confirms it. They find something that confirms it. They don't look actively for something that disproves this initial theory of harm. So that's really a problem on the substantive review. And as I said, there's no real evidence hierarchy. There's no witness testimonies and so on. So, you know, take the document at face value, say I can ignore the market test. That's really an issue. And Dow DuPont was a good example. The Commission advanced an innovation theory of harm there. The merger would be bad for innovation. The market test was clear. 75% of customers said that the innovation will be as good or better after the merger. And still the Commission had its own theory of harm. It relied on some selective quotes from internal documents and said there's going to be less innovation after the merger. So that's another practical problem. Just going through a couple of more details here, and I'm conscious of time. This is just the point about the intervention rate and whether there's an impact on substance. So if you look at the second to last line from the bottom, you see that over the past 5-year periods, if you look back 15 years and break it into 3 buckets of 5 years each, the overall intervention rate, so the overall rate where a merger was abandoned because of competition concerns, cleared only subject to remedies, or blocked, is roughly the same, around 7 to 8%. But if you look at the cases excluding the simplified, the fast track cases, then you've seen a massive increase. You have now, in non-fast track cases, a chance of 1 in 3 that your deal will not be approved unconditionally. So unconditionally in phase 1, that is. So this coincides, right? The focus on internal documents coincides with a tougher stance on substance, especially under the tenure of Commissioner Vestager, who took over at the end of 2014. And I do think that very often these documents have been used primarily to strengthen a theory of harm, to strengthen concerns. Rarely there were concerns on the face of the merger because of market shares, and then the documents disproved them, right? That is the exception. Just briefly, what is the document? What is the type of documents that we're looking for? So somewhat similar to the Brazilian system, there are some documents in the EU that you need to submit with the notification. That's much less than in the US. It's somewhat similar to the 4C, 4D, but it's more limited, what we have here. And it's really a focus on the transaction documents dealing with the transaction rationale, reviewed by the board or a similar body. And then if there are specific competitive analyses that the company does in the ordinary course of business that relate to the markets at issue, you would have to produce them too, but only from the last 2 years, right? What happens in pre-notification beyond this stuff that you have to submit with the notification anyway? Well, the Commission can generally request anything that they find useful. So that extends to documents. In the phase that is prior to the notification and pre-notification, they don't really have a lot of sanctions because there's no formal procedure in force yet. So it's really, they ask for something and it's in your interest to provide it because you want the Commission to be comfortable that they have everything to start the formal clock. And then once you are in phase 1, the formal rules of document collection apply and also the sanctions. So there's either a simple request that does not carry any immediate consequences if you miss a deadline or can't produce it. But if you don't, they will issue a document request by decision. And then if you fail to meet that, that will stop the clock then, and the deadline is suspended. If you look at what's then the scope of these document requests in pre-notification, it's typically relatively generic. It's the generic description of we want all competitive analysis, we want all business plans from the last 3 years, we want documents prepared in the ordinary course of business discussing strategy, sales, R&D, innovation, whatever. So it's really a descriptive way, but can be very extensive. This was really endowed upon, it was RFI 1, question 1. It was really, 3 years, all of these documents that took quite some time to collect. Once you're in phase 1, it's relatively similar. The big ticket document requests typically don't happen in phase 1 because phase 1 is very compressed. It's just a bit more than a month, and they need time in the internal hierarchy to have a draft decision, have it approved by the hierarchy, and so on. So the actual investigation, once the clock starts, is really only 3 weeks. So they don't really have time to look at a lot of documents in that close deadline. Phase 1 is really focused on the market test, getting formal answers from customers, from competitors, and so on. And then once phase 2 starts, in the first 2 weeks, you immediately get these document requests. And they can look differently. You would normally expect a list of custodians. And this will be, you will get a request to provide organizational charts of the parties, and the Commission will then identify the custodians that they think are interesting, that may hold interesting documents. And you get search terms, typically with an asterisk to cover word variants. and you have to collect all these documents from these custodians, often for more than 3, 4, sometimes 5 years, run all the search terms, produce all of those documents that hit on the search terms, hold back only what is privileged, and also give them a whole log of what you've produced. Sometimes, again, also in phase 2, they're more descriptive. Please provide competitor analysis. So you don't have an easy job by just collecting all documents and running search terms. You somehow have to figure out, how do I find documents in that custodian's mailbox that respond to this descriptive request? This would be another example of, the broader type of descriptive requests, and this can be relating to the typical topics that are relevant for the competitive analysis. What we don't have, contrary to the US, is the concept of substantial compliance. So the deadline only resumes, assuming that you will have a suspension of the deadline. The clock will be stopped because you can't meet that 1-week deadline. The deadline only resumes once you've produced fully. And that means everything you've held back for legal professional privilege, the commission is fine with. Yeah. So there's no clawback mechanism. So you don't want to be overly generous with them to start the clock early, because it's not easy to claw the documents back that you should not have produced if you had time to review them properly for privilege. And you have a problem sometimes in the US with litigation. If you produce it to the commission, there can be a discussion of whether you waived privilege, and these documents may be relevant for whatever patent litigation in the US. So this may have very serious implications. So it's really burdensome in practice. You will rely on professional vendors. Typically, not many law firms have in-house capabilities to run all of this internally. You will need tons of contract attorneys who actually do the review based on the search terms. And then you need specialists, and those would typically be either with the vendors who are used to these processes, or internally with the law firms that know how to produce these documents. And here's an example of instructions of how to produce them in electronic format, what type of file format, not password protected, on a USB stick or a hard drive, list containing metadata. They also want the glossary so they can understand them. All of this you have to do in the 1-week deadline in theory. Legal professional privilege, that's really an important topic. And let me just spend 20 seconds on that. The European Commission is not, I would say, not very good in accepting broad legal professional privilege claims. They really apply the same case law as in cartel cases. And in cartel cases, LPP is relatively limited because it's, of course, an exception to the investigative tools of the European Commission. And they're trying to find secret cartels. So it's understandable that their LPP is somewhat limited. I don't think the same rationale can apply in merger control, where they have, stop the clocks. You have to provide all of this information under the form of the filing and under these RFIs, and to basically say, I need to be very restrictive on what I accept on LPP because it's an exception from my investigation powers. I don't think the same rationale applies as in cartels, also because mergers are not inherently harmful to competition, contrary to cartels, right? So again, I think this is, I don't want to spend more time now up front and rather have more time for questions later, but it's really a practical problem to figure out how to protect LPP appropriately in these cases. On a substantive review, I've said, it's really key evidence, especially where they pursue novel theories of harm. All of these documents are, of course, nice evidence because customers may not have come up with these theories of harm. So what evidence do you have? Well, there's something maybe in the documents that you can cite. We don't have clear rules for the review and how to balance documents with market test results and the whole body of documents versus some selective documents. And we don't really have a process to introduce witness statements. In mergers that are reviewed in the US as well, we may have depositions in the US and transcripts from those depositions. We've often tried to use them, but the commission will treat them just like party advocacy. They won't treat them as evidence like they will treat documents. Last point, and then I'll kick it over to Doug. We also discussed briefly, what about data rather than documents? there is an increased focus on economics and econometric analyses in complex merger cases. The actual scope of the request varies widely, and the same is true for the document request, right? There are cases that we've handled that are really, they were on the verge of phase 2. They were just barely cleared in phase 1 without remedies, and they didn't really request a single document on top of what you have to provide with the Form CO filing. In other cases, even a very simple case in phase 1, they ask for all kinds of documents. There's no clear rules. You can be sure once you're in phase 2, there will be a massive document request. That's as clear as it gets. On data, it's the same. You know, phase 2, you'll have a massive data exercise. Phase 1 depends. In DowDuPont, they were actually asking for a copy of the entire SAP databases of the 2 companies. Listed companies with revenues of $50 billion had to provide their entire SAP database to the European Commission for them to play with. And then once you introduce proactively economic advocacy or based on an RFI, they will also want the raw data. They don't want just, you know, the memo from the economists that have the results of the analysis. They will want all of the raw data and check the results against the raw data themselves. So that's what you see on the data front. With that, let me kick it over to Doug for the US, which has been doing this for a much longer time. So we're learning a lot still day to day on how to handle this in practice from our US colleagues who do it all the time.
Thank you, Tilman. And if I might ask you to, you have control of the screen, so I might ask you to flip the slide. But before I start, Lauro, I think your frustrations with dealing in a U.S. investigation, merger investigation, hit on a lot of our key themes that we also are frustrated with. And you'll see there's a lot of commonality with what's going on in the EU with how we've been dealing with these issues for probably, I mean, the HSR Act was passed in 1976. So, you know, we've got about 40 years of experience. And when I started over 20 years ago, it was, we were looking at paper. We would have 400 boxes of paper that we would flip through, and you'd flag for responsive documents, and that's what you'd produce. Now everything's electronic, but just to set the stage, you know, our merger review framework in the U.S. is a little different. So we have an HSR Act that requires parties to notify both the FTC and the Antitrust Division of the DOJ, really based on the size of the transaction, which currently is in excess of $92 million, or the size of the parties can also come into play. But once you're over $368 million, the size of the parties doesn't matter anymore. So once a filing's made, there's a 30-day waiting period before the parties can consummate the transaction. Certain transactions have a 15-day waiting period. So I think particularly in the last several years, the number of HSR filings is just sorry, I had a call coming in over my computer. This year we're at the highest level ever. So over the last several years,
you can see even on vacation, Doug is a very wanted man. So.
Exactly.
Right. Sorry about that. I have my all right. So, but yes, yeah. So we're in what we call a merger wave in the United States, especially. So for the first 3 quarters of the fiscal year, there are over 2,400 transactions filed, which is more than we've had since they raised the filing limits several years ago. So next slide. But what I think is important to understand is just most HSR filings go through with no enforcement action, even no contact from the enforcement agencies. So we're here to talk mostly about second requests and the burdens on the parties. And as you'll see, if we have over 2,000 HSR filings, we really, the agencies together, either agency, but combined, they only issue between 50 and 60 second requests in any given year. And then even there on the chart on the right, what happens, how many mergers are blocked or prohibited. It's really anywhere, averaging 16 to 19 in a year. The current numbers for the most recent years are about on track with that, you would think. And we're just into our new administration who wants to be really aggressive, but so far numbers are about consistent. But when you do get a second request, there's several phases in a merger filing in the US where you have to submit data and documents. And some of this is very similar to what Milena and Tilman have already described. But for the HSR filing itself, you have to provide a description of the transaction. You have to provide a breakdown of the filing party's revenues from US operations by product or service. And that can sometimes be difficult, particularly if you were a Brazilian-based company. You have to classify your revenues based on codes in the US, which can be somewhat burdensome, believe it or not. And then, detail on the worldwide corporate structure, including significant minority holdings. That's also sometimes burdensome if a party hasn't done it in a while. And then item 4C and D documents, which a lot of people may be familiar with, but these are similar to what you might see in a long form in Brazil or Tilman discussed for some of the EU filings. But it's a pretty specific definition about documents prepared by or for any officer or director that analyzes the transaction and discusses certain topics like competition, competitors, sales growth or product or geographic expansion. So it can be broad, particularly if your executives, your CEO and CFO have a lot of emails back and forth about the transaction and what it means, and they start talking about what it means for competition, how they're going to grow. Sometimes it can become a mini document production in itself, but usually it's just things like board presentations and the information memoranda, some analysis of synergies. And then there is a filing fee with the HSR that, depending on the size of the transaction, and that ranges anywhere from $45,000 up to $280,000 for transactions that are $919 million or higher. So that's the first stage where you have to give data or documents. If one of the agencies decides to investigate the transaction, and another quirk of the US system is our US FTC and DOJ antitrust division have concurrent jurisdiction. So either one can investigate a merger. They have an informal clearance process where they pick or negotiate on who gets to investigate a merger. Certain segments like pharmaceuticals always go to the FTC, or defense industry mergers will always go to the DOJ, but occasionally there are clearance battles that will eat up most of your waiting period. So, but if an agency does launch an investigation, it is confidential, but that is the chance where the parties start to present their arguments about why it should be cleared without further review. And during that period, you'll typically get a voluntary request, which is another situation where you're asked to give documents. And again, it's a pretty truncated period. So you could be asked for information on your top customers. The government will take those and they'll actually start calling customers and asking them their views of the transaction. And they'll ask for strategic plans, particularly those not produced with the filing itself. They'll want to see any historical documents and entry and competition. They want to know about historical pricing, business plans, other type of materials that would be relevant to competition. This is all voluntary at this period. You don't have to give anything over, but we always say nothing bad in the first 30 days. You're trying to make your substantive case as to why the merger is pro-competitive, but there's a lot of judgment calls there about what you should give and what you shouldn't, depending on the chances of going to the next phase, which is our notorious second request. So that would be the next slide. So what happens when you get a second request? So if they don't clear the transaction during the waiting period, they can either issue a second request or allow the transaction to proceed. The parties can also pull and refile once if you want an additional 30-day waiting period. That happens a lot today, and it's becoming more the norm because of the number of HSR filings, the agencies have slowed down in the review or in the clearance process. So you often don't get a call from an agency until 21 days into your first waiting period. So it's usually a decision to give them another 30 days to go through that voluntary request process. The important thing is the second request, if it's issued, it pauses the statutory waiting period in the US until both parties substantially comply or the DOJ or FTC closes its investigation. And substantial compliance means exactly what it says. You have to substantially comply with the second request as it was written or as you've modified it through negotiations with the agency. The importance of substantial compliance is that once you do substantially comply, the parties get to control the clock. The government's back on another 30-day waiting period where they have to make a decision as to seek an enforcement action, which would be usually go to court to block the deal or get a preliminary injunction against the transaction, or allow the deal to proceed or work out some type of divestiture remedy. Often we extend that second 30-day waiting period through what we call a timing agreement, where you would negotiate soon after the second request is issued. Timing agreements often done in conjunction with negotiating for limits on the second request to reduce the burden on the parties. We talked about custodians in the EU example. We often limit the custodians by reviewing organizational charts with the DOJ or FTC to cut down on the number of custodians that we have to, whose documents we have to collect and produce, or on the amount of data or other factors that try to reduce the burden on the parties, which helps on timing, but also helps on the limits, limiting the investigation. But yeah, the ability to control timing is really an important factor. And so that's why you'll see that parties often race to comply with the second request as fast as possible so we can get the clock moving again. Next slide. So what does it mean to respond to a second request? There are two model second requests that the FTC and DOJ each publish on their websites. I sent copies to Guilherme and Milena, I don't know if they can distribute them, but they're interesting to read. Each is about 12 pages of requests and then another 10 pages of instructions and definitions. But to respond to a second request, I think generally it's similar to what Tilman described, and in some ways it's not much different than a lot of other places. It's just we get it all in one big document. So we get a number of interrogatories that cover a wide range of questions about the party's business, customers, competitors, potential entrants, what are the synergies and efficiencies, transaction timing, and other factors relevant to the industry. Sometimes on the supply side, they may want to investigate that. We're also asked to produce relevant data and describe data sources and where the information comes from, particularly transactional and cost data, because the government's economists want to run some economic models, and then Salesforce data, CRM type data. Do you track your wins and losses or interactions with customers, and then bidding and pricing data. And to do that, similar to Tilman's description, we have to go out and vacuum up almost every relevant electronic and paper document. That usually going back 2 or more years, probably 3 years is typical now. And it usually comes from the executives, managers with product level responsibility, or sales employees are often important. We do try to limit it by the custodian, so we negotiate over organizational charts similar to what Tilman described. And I think one of the differences we've already noted a little bit is in most second requests, we'll also see depositions of key business people. And that is sworn testimony in the United States. And they will, the government will, they usually can last up to 8 hours. Technically, they can go 2 days for some people. But it's a lot of testimony about the rationale behind the transaction, about competition, and the government will use the documents that they collected as exhibits during the deposition and question the executives. So that can be a lot of work in preparing the executives, but it also can be an opportunity to really sell the deal rationale. And if we as lawyers do our job, you can really prepare the executives to highlight the key themes about the transaction and why it is pro-competitive. So next slide. I think it's important to understand when they define a document in the second request, it's more than just a piece of paper. And this is maybe what's changed over the years. Like I said, when I started, we were looking at boxes of paper, but now the term document is very broad. So it's anything written, printed, or electronically stored. ESI is a common term. But so that includes social media accounts. If your executive uses Twitter or Facebook to comment about the transaction or competition, if they use chats or instant messages or text messages, you have to collect those. So we just had a transaction where our CEO used texting for work, and we had to collect the CEO's iPhone and review and process the chats and texts from the iPhone. And we use the word metadata. The metadata is really the electronic footprint of a document. I don't know if you've ever looked at it, but metadata includes, who sent it, who received it, who was copied on it, the last user date, the last time it was modified. All that data is hidden in an electronic document, and you have to produce that as well. A lot of times formulas or other embedded things in documents we have to include. Now we do get some relief, things like bills of lading, invoices, that type of thing. Really, we don't have to produce, but just a document is a really broad, inclusive definition. Next slide. Some of the burdens, and Lauro, I was laughing a little bit because you flagged a lot of these when you gave your introduction, and I think and there's a few more we can talk about if we probably had another hour or so, but I think Tilman, can you go back? Oh, the other way. Hey. Oh.
Which one were you going for?
You gotta you're going backwards.
So this one?
The burdens of responding. Yes. Just to highlight a few of what's required. I think a big thing that isn't appreciated until you get into the process is A second request requires a lot of attention and work from the company's executives, particularly the financial and sales functions. If there's a general counsel or internal legal staff, they're also involved, but it's work outside of their 9-to-5 job, so that they've got their job running the company, and then you're asking them to put in, 8 hours on your second request for a couple months. You also have to hire an economist to deal with the agency's economists and to deal with the data and analyze it. It's very hard to do it within the law firm context or have the company do it themselves. And then Tilman brought this up too, but you also have to require a specialized e-discovery vendor. They're specialized in the collection, processing of the documents and how to produce them to meet the standards that the government sets. Tilman showed examples of the EU, and the US is very similar, but very, very specific instructions about how you have to produce the documents. In maybe one big development in the US that we use now is we're allowed to use technology-assisted review. It's also called predictive coding. Actually uses artificial intelligence to identify what the responsive documents would be. It cuts down on the number of contract attorneys. It can speed up the process, but that also means you don't see every document before you produce it to the government. So there's some trade-offs there. Technology-assisted review is supposed to be more accurate than people, believe it or not, but you still have to do a privilege review. And then the work by outside counsel to actually respond to the second request, write the narrative responses, is a lot of work. So those, maybe the last burden that we can maybe talk about a little more is coordination with the things like the EU process or other countries that are doing similar investigations, and how do you bundle it all together to get some efficiency or make sure you're consistent in what you're saying to the competition agencies around the world, because they also do eventually talk. Next slide. So just quickly, what do we try to do, or what other things that you need to keep an eye on? We try to negotiate the scope and narrow it as much as possible. The agencies will only go so far, really for two reasons. It's their only chance to collect data and documents to investigate the merger during the HSR process. And they also want time. So the longer it takes you, the more time they have to do their investigation. It does trigger data preservation requirements. So if you get a second request, you have to go out to the company and make sure they issue hold notices. They suspend any data and document destruction policies that would overwrite potentially relevant data. So sometimes certain servers or email might get overwritten after a certain period of time, and you have to suspend that because you don't want to be accused of spoiling any relevant information or deleting it. Data privacy issues are a huge burden these days. We usually can get around them, but it can take a couple weeks or longer to figure out how to transfer the data to the US from the EU or other countries that have data privacy laws that are stricter than the US. And then I know Lauro gave a very recent example, I guess, on this, but we do have to translate everything into English. And that can be quite a burden and really add a lot of time to the response. Next slide. And maybe the last couple, obviously, we have broad concepts of attorney-client, attorney-work product, and legal privileges in the US, which is great for protecting the company. And those can be withheld from production or redacted, but that means we have to do a privilege law, which is another substantial undertaking. And as you'll see in the examples, they can be quite long. We also have a refresh obligation. So what you produce has to be fresh. So it has to be current, at least for some of the categories, up to within 45 to 60 days of when you substantially comply. it usually means you got to move fast, or you're going to have to do some of this twice. And then what's happening in the U.S. Is they're expanding their areas of focus. So we haven't quite seen it yet in the second request we've dealt with in the last year and a half, but the U.S. agencies are starting to look at merger effects on labor markets and suppressing wages. They want to start looking at mergers and how they impact environmental, social, and governance issues. And then whether or not they change the laws in the U.S., they might change how we report mergers, or what mergers are almost per se illegal if they're of a given size in a given industry, like the technology industry. So just to wrap up, I wanted to give a few quick examples of what all this means in terms of numbers and burden. And so we have a few real world examples to explain. I don't know if the merger size always matters so much. Maybe it motivates the parties to move a little faster and put more resources into a second request. But we had a $57 billion merger a few years ago. We substantially complied in 4.5 months, which was a huge undertaking. And this second request had 66 separate specifications and 149 subparts. We produced 4.17 million documents, and we had 112 document custodians, and really a very long narratives and 3 terabytes of transactional data, which a terabyte, if that was printed out, I think we'd go to the moon and back in terms of paper. It was a lot of data. A smaller merger, but where we substantially complied in a very short amount of time. But the burden was smaller, but because of the time crunch and some other issues, it was in some ways just as intense. We had 13 custodians, but there was also a Japanese investigation. So they added more custodians, they added search terms, they added other things that just layered on top of everything else that was going on. There was 500,000 documents, so it was actually a relatively pretty small second request, I think. But we had to collect documents in the US, EU, and Asia. So literally remote, you would do a Zoom with the vendor, the custodian, a couple lawyers, and have to collect, particularly this was during COVID too. So everything was done like this. It was quite an accomplishment in the time. And as you'll see, that transaction, we had a lot of privileged documents because there was a lot of IP and that type of litigation and things. So we had a privilege log with over 45,000 entries where we withheld 45,000 documents from production because of privilege, but we had to log all of those. One more quick example on the next slide. This is a bigger merger, $4 billion. It took about 5 months to substantially comply. It was a global transaction, 5 different countries. We had to collect documents from custodians in 5 different countries. It was a similar process. It was all done remotely. We had multiple languages for review and translation. I think it was about six primary languages from European-based languages, Asia, US, and then there we collected 4 million documents. We used TAR, that technology assisted review, and we were able to produce only 2.2 million documents, and along with the interrogatory and transaction cost data. So those are some real world examples of what it really means, what you have to do to substantially comply, and then really what happens after you substantially comply. And that's there's 3 options for the government. The government has 30 days to make a decision unless you give them more time. And the typical is you give them 60 or 90 days instead of 30 days. But there's 3 outcomes. They can close the investigation and let the transaction go forward, which happens in some cases. I think more likely you're going to enter into some type of negotiated agreement that includes divestiture or other provisions, remedies to preserve competition. But that can lead to additional data and documents. You have to provide data and documents on what your divestiture is, who the buyer is, and so that's another area where you would have to do that. Then the last thing is they could seek to stop the transaction by filing for a preliminary and permanent injunction in federal court. And then that leads to U.S. discovery all over again in the merger litigation. And you would go through something like a second request all over again, but under in court and in a trial context. I went through it pretty fast, but it's hopefully we left time for questions, and happy to elaborate on any one fact.
Fantastic, Doug. Thanks a lot, Till. It was very impressive that you could, in less than 1 hour, to provide such a comprehensive scenario about what is happening in the US and in Europe. I believe that we have some questions. I know that we started a little bit later. But Milena has a few questions. We may receive some from the audience. I have just received one here. And perhaps just you mentioned Japan, and that also made similar requests. Apart from Europe and US, are there other jurisdictions or countries in which these requests for electronic documents are more common? Do you see any trends in this respect?
I think our recent experience is Japan is always very active. Canada also, if a transaction is reportable in Canada and has some issues, Canada can issue. And we did one a couple of years ago, issue something very similar to a second request, and it's a similar procedure. Other than that, I haven't had any recent experiences. I think most of the other countries are probably similar to Brazil in how they go after things. Tilman, I don't know what you think. Mexico is one that's been active, but they don't ask for a lot of documents.
No, I agree. It's Canada. It's to some extent Japan now. Also within the EU, it's typically member states like Germany. It's not as excessive as the European Commission does it, and those are really currently the US, EU, Canada, and to some extent Japan are really the key agencies on the document front these days. Yeah.
Very good. Milena, do you want to?
Yeah. Thank you, Ribas. I was thinking all the time here that, like, when we're speaking about custodians, word variants, search terms, and discovery vendors, it takes me all the time to a cartel investigation, right? Because we're not used to using those terms to a merger review. And I was wondering, how do you manage, and how do the authorities manage, right, to review such massive amount of documents, and especially under significant time pressure, right? Because in a cartel investigation, we have much more than a week to conduct all the document review. So I was really impressed, and I have to say a little bit concerned too, because I think I see this coming here like at some point, and I don't know, we need to figure out how to manage this. And but that leads me to a question that I was thinking here. I read a paper recently, I think by an European lawyer, that said that the level of scrutiny and intervention in merger reviews, of course, has increased so much that one can question if the regulators now see the big mergers as like ultimate cartels, which would depart from the presumption that mergers are, or at least are supposed to be, welfare enhancing. So with that in mind, I have two questions, I think in particular for you, Til, because I think this is a more recent trend in the EU. Do you think that this view, that this level of intervention is a different way that the authorities see the mergers, is an overstatement, or this is how this reflects the market reaction to this kind of intervention?
Yeah, I think there's some truth to this, right? Definitely under Commissioner Vestager and then the chief economist that was in place then, who's still very vocal about cases, although he's not on the job anymore. They really thought that their predecessors had been too lenient with mergers. You have also this era of fairness, the concentration of economic power, the growing income inequality. So somehow people think, big is bad, which is something that, has come in waves in the US as well. Mm-hmm. And I think that you can really see that in the statistics, and you can also see that in, for example, how the Commission has approached this concept of the parties being close competitors. So the idea with that concept was that in differentiated markets, where let's say there are 4 big players in the market, they may have very differentiated offerings, and maybe the parties are very distant competitors. So although their market share looks suspicious, they're actually not competing much. So there's not much competition lost and prices won't go up. Whereas even if their market shares are more limited and they're very direct alternatives, then there may be a bigger impact on pricing than the market shares would suggest. And the Commission has really employed this also in homogeneous product markets and really made this a hollow concept. Everybody in an oligopoly is a close and important competitor. And that got quashed by the Court of Justice in the CK Telecoms case. So we do hope that the Commission going forward, if the judgment is confirmed, will be held to a higher standard. The same is true for efficiencies. Efficiencies it's in practice impossible to win a merger on efficiencies because the parties bear the full burden of proof and have to show that the efficiencies are merger specific. Again, the court in CK Telecoms quashed and said every merger brings some efficiencies, and the parties just need to prove, very specific efficiencies that will be out of the ordinary. And there have been academics like Carl Shapiro that have advocated for an efficiency assumption, right? If you, under the UPP test, assume there's a price increase in every merger, there should also be a presumption that there's an efficiency in every merger that counterbalances that, and only if the net effect is negative, then you can block it. The European Commission, the chief economist team, when I talk to them, they really don't believe in that anymore. They don't think that horizontal mergers generally creates efficiencies. And now they have a court telling them otherwise. The judgment is under appeal, so we'll have to see how that goes. But there's some truth to this, that kind of this notion of 2 parties eliminating competition by way of a merger is almost like a cartel offense.
Okay, thank you, very clear. Lauro, you raised your hand?
Yes, a quick question about the legal privilege. Okay, what's one thing that concern us a lot is how to deal with our opinions and risk assessments and exchanging emails with lawyers abroad. Meaning, sometimes, if I understood correctly, Brazilian lawyers does not own the privilege, are not entitled to the privilege. But if we exchange opinions and risk assessments with independent lawyers in Europe and the United States, we are protected by the privilege. My question is, in relation to that, do you have any kind of experience, advice to us on how to deal with that? And one question, in-house lawyers has any kind of privilege, meaning that can we exchange opinions with in-house lawyers and be protected, or it is not possible? Meaning, how do we deal with that? How we Brazilian lawyers deal with that questions in both in Europe and the United States?
Maybe from an EU perspective. So that's the one thing where the Commission is relatively quote unquote generous, right? They will say in a global merger, although technically they say only EU qualified external counsel benefits from the privilege, they will accept privilege also from US qualified or other lawyers in the merger investigation. So that's at least my personal experience. In-house counsel, no. In Europe, no. Of course, if you as an external lawyer exchange with the in-house counsel, that may still be privileged if it relates to the scope, as I've explained. But other pure in-house to business, for example, an email from an in-house lawyer to a business, under EU law, no way that's privileged, unless it is limited to really just reporting what external counsel has said. If you can't prove that it's really limited to that, then it's not protected.
In the U.S., our protections are pretty broad and would cover most of your scenarios, Lauro, and be broader than Tilman's example. So, for example, if we had a European custodian that was exchanging emails with a European in-house counsel, we would still claim privilege on that in the United States. One of the issues that comes up, though, is if you can't claim privilege in the EU, and we can in the United States, at some point the agencies talk. So if there is relevant evidence that the EU uncovered from some of those communications, they may be able to talk to the US authorities about it. And you could get into issues of waiver of privilege, and we would not be required to produce those in response to an investigation in the US.
Let me ask you a couple of final questions. Let me know if there is time for that. But we are running out of time here.
I'm already 15 minutes late for another call, but sure, one last question is fine.
Yeah, okay, thanks. Just we have a question from Daniel Andreoli from IBRAC as well. Do you believe that information requests is a way for the authorities to have more intelligence on the companies that can be used as the basis for conduct investigations? How you can conciliate this fishing expedition with the rights of defense and the constitutional rights for not self-incrimination?
That's a very good question. I haven't seen this in the EU yet. We've been involved for a client that wanted to make a complaint against a competitor for abuse of dominance, and we would have used something that's in a published decision, in a merger decision, and we would have, of course, tried to motivate the commission to look at their entire file, or at least the merger file. But I haven't seen standalone investigations arising from a merger, like a cartel investigation or abuse of dominance or something like that. These are also normally separate teams in the commission. They're not as separated as in some other competition authorities, but they would find that somewhat unfair. I mean, we also have these sector inquiries, right, where you look at an entire sector, not specifically individual companies, whether there are structural problems in the sector. And even there are many in the commission that say, if I find something there and use that as a conduct investigation, exactly what you say, the right not to self-incriminate, that's problematic. So it's not a real risk at this point in time. I understand why companies would be concerned, but we haven't seen much of that, if anything.
So in the US, we do know that in limited circumstances, a merger investigation could lead to another investigation. So, for instance, if there was cartel behavior happening by one of the merging parties and that information was turned over to the government during a merger investigation, there might be a spin-out investigation. It would have to be, so the DOJ would have to refer it to their colleagues in the criminal enforcement section, or the FTC would have to refer it over to the DOJ, because the DOJ can only enforce and investigate cartels in the US. But it doesn't happen a lot. But it is a possibility. So we're always aware of that when we do merger investigations in the United States. Just maybe depositions in the United States, they are under oath. So you're sworn to tell the truth. If an executive or somebody were to lie, there is a possibility of penalty of perjury in the US, which could be a criminal charge. But the executives are testifying in their capacity as an executive of the company or on behalf of the company, and not in their individual capacity. But if they were to testify to something like cartel behavior, that could spin off into another investigation. So those would be the risks in the US.
Very good. Thanks a lot for both of you for joining us in this panel. Very rich conversation. We have some materials that Till and Doug provided us with. We will be happy to circulate with everyone here. Thanks for both committee members to join this conversation. We'll certainly have other opportunities to talk to Till and Doug. And as Lauro said before, we look forward to seeing you in person soon. For those of the investigations, the compliance investigations committee, please stay at this room because we will continue with the ordinary meeting of the group. Thanks a lot, everyone. Milena and Lauro, thanks a lot.
Thank you.
Thank you.
Thank you all, guys.
Thank you.
It
was great.
Thanks for having me.